All right, we are recording and I'm gonna pull up the contracts
Perfect.
that I've been given.
Hopefully they're same order that I have.
Oh, no, we never do that. Come on. Yeah, we just like to, keep you guessing.
Exactly. All right, I think we're ready to get started.
Okay, let me just make this bigger so everyone can see it.
Sure.
All right, it's all yours.
All right, awesome. I just have to reorder some of my disclosures here.
I think, because this was a leftover from yesterday, because we got
Oh,
cut short,
okay.
but I think you should be fine. So,
All right, that's why she did that. Okay, got it.
yeah, yeah.
All right, well, we'll get started. This is day 4 of seller documents, and we're just going to continue from yesterday. I don't know how far into the agent visual inspection disclosure that she got, but we will start over.
Yep, we didn't get to it at all because we were cut off because we had to go to another meeting. So
Oh, got it.
it's all
Okay.
yours.
Okay, good. All right. Well, the agent visual inspection disclosure is a very important piece of paper in a real estate transaction because it is your visual inspection of the transfer disclosure, and you have to fill it out yourself and then hand it over to all parties. So the agent visual disclosure is required for any property that is 1 to 4 units. California law requires, with limited exceptions, the real estate broker salesperson to conduct a reasonably competent and diligent visual inspection. What that means is you need to start at the front door and go wall to wall to wall and note anything that you see at the property. And we'll go over how that is because it's real important how you word things and real important what you write down and how you write it down. So you don't have to open doors. You don't have to, or excuse me, you don't have to open cupboards. You don't have to go underneath sinks. You don't have to do those kinds of things. But what you do have to do is do a visual inspection, like I said, wall to wall to wall. So on the first page of the agent visual inspection, it basically gives the inspection limitations by the agent. It says that you're conducting a reasonably competent I cannot talk this morning, diligent visual inspection of reasonable and normal accessibility areas of only the property being offered for sale. So you don't have to climb into the attic. You will not have to move or look under, behind furniture, pictures, walls, floor coverings, things like that. You will not have to inspect beneath the house or any other structure on the property. You don't have to climb up and down a hillside. You don't have to move plants and look behind them. You're just looking for what you see as you walk through the property. You will not have to operate appliances. You will not have to do any kind of electrical, plumbing, pool, spa, cooling, septic, any of those kinds of things. Size of the property, you will not have to measure the property. Environmental hazards, you don't have to disclose whether there's mold, asbestos, lead-based paint, radon gas, formaldehyde. You're not going to be able to see those things. Those are more of what the physical inspector is going to do. Off-property conditions, you're not obligated to pull permits or inspect any public records. You will not guarantee views or zoning or any proximity to transportation, school, or law enforcement. And I will say, especially schools, boundaries for schools change all the time and they don't have to give anyone any notice. So you never want to put in your Avid that a boundary has changed. You'll always refer them to the school district so they can look stuff like that up themselves. A lot of agents get in trouble for stuff like that. Analysis of agents' disclosures. It's purely a visual inspection. Agents will not provide an analysis or determination or the cause of any repair or possible repair. So with that, the buyers and sellers both need to sign the front page. And now it's time to do your inspection. So like I said, the best way to do your visual inspection is to start by at the front door. You're going to fill in the date and time that you are there. You're going to state who is present. So it could be the inspector, it could be the buyer, it could be the seller, it could be you and any family member that happens to come. So you want to make sure that all people that are present are listed on this Avid. You want to state the weather conditions, whether it's raining, sunny, cloudy, snowing, which it wouldn't here, but that's an issue. So when you start your visual inspection, I always start at the front door, like I said, and you want to say whether there's an entry or not. So if there's an entryway or a separate like walkway to get into the property, then you want to note that. If it just, you open the door and you're in the living room, you want to note that, like there's no entry. If there's nothing that you see on the walls, or as you're looking at the entry, if there's nothing that you see is wrong, then you write nothing noted. So you always want to fill something out on each one of these requests for the living room, dining room, kitchen. You want to fill something out. So either there's nothing noted or there's something noted. A lot of times people will put, oh, it's got a tile floor or it's a wood entry. You don't have to put that because that's not what your job is. Your job is to note defects as you see them. So I'll make things up as we go and I'll tell you when I'm making things up. So the last Avid that I did, the entryway was right at the front door. So when I walked into the front door, the living room was present. So I put no entry, and then I said nothing noted because I didn't see anything wrong, and I explained that there was no entry. The living room, so you're going to go wall to wall to wall in the living room. I always go to the right. And so anytime you're doing an Avid, you always want to have a standard level of care for how you do your business every single time in every single property. So that if someone says, how did you do the Avid? You can say, I started at the front door and I went wall to wall to wall in the living room, which led to the dining room, which led to the kitchen, which maybe led to a bathroom, and you made it back to the front door. So that if you ever went to court, you could say how you did your inspection. That's very, very important. So this is just like a transfer disclosure statement, except you are the one doing this form. So when you get to the living room, if you go to the right of the inspection that I'm going to be talking about today, there was a fireplace. And in the fireplace, it didn't look like it had been cleaned in a very long time. And it had wood in it. The other thing is there was no indication of a gas turn-on valve. So I wrote on my inspection that the living room had a fireplace, that the buyer may want to get assistance with a chimney inspector to clean it, and that there was no gas turn-on valve present. So it may be only a wood burning fireplace. In the living room, I saw scratches on the floor. And I saw some peeling paint near the window. Those are the things that you're going to write down as you're going through this Avid. The other thing in the living room is there was built-in bookshelves, and you couldn't tell whether it was built in or whether it was just sitting on the living room floor. If you don't know whether it's a built-in or not, you need to put on your Avid that you're unsure that it's a built-in, that it will stay. Because if it's just a bookshelf sitting on the living room floor, then that could be taken at the close of escrow by the seller. And you don't know that. The living room goes into the dining room, and the dining room has a dining room table. You don't really see anything that is awry, so you write nothing noted. In the kitchen, the dining room leads to the kitchen. The kitchen has stains on the cabinets. So you see the stains on the cabinets and you write stains. You don't write what kind of stains they are. You write just that there's stains on the kitchen cabinets, because you don't know what kind of stains they are. It could be olive oil for all we know. You just write stains. That gives the indication to the buyer that they may want to investigate that further. All you're doing is saying what you see. The appliances, there's scratches on the stove. There is cracked tiles on the counter. There are scratches inside the sink. There's a window that looks out, but guess what? The trim looks like it is deteriorating. So you're going to write all of those things in those 3 lines on your Avid about the kitchen. And then off the kitchen is a pantry, which is another room. So at other room, you're going to write pantry. You're going to make a dash, and then you're going to look in the pantry and see if there's anything going on in there. Well, when I looked in the pantry, I looked up to the ceiling and I saw there was a hole in the ceiling at the top of the pantry. I don't know what the hole's for, but there's a hole there. So you're going to write that there's a hole in the ceiling. When you come out of the pantry, there's a hallway that goes to the bedrooms, bathrooms, through the back of the house. You're going to go down the hallway and you're going to look from the bottom of the floor to the top of the ceiling and decide if anything is going on there. Most of the time in a hallway, you're going to see a lot of holes for pictures. A lot of people put pictures in their hallway. And maybe there's a different type of flooring. So instead of saying there's hardwood floors in the living room, dining room area, and there's tile in the kitchen, and there's wood in the hallway, you may just say that there's several different types of flooring on the floors in the house. Off the hallway, you lead to bedroom number 1. So you write number 1 at the bedroom, and then you go wall to wall to wall in that bedroom and decide if there's anything that you see, whether there's peeling paint, whether there's crayon on the wall. In the inspection that I did, there was a rock climbing, all kinds of little rock climbing things on the wall. So I put that on my disclosure because that's unusual. You don't see that every day. Number 2 bedroom is the one across the hall. And I usually say where that bedroom is so that they know how you're walking through the property. So number 2 bedroom across the hall, and I don't see anything in there that has come to my attention, so I write nothing noted. Number 3 bedroom is the master. It's at the end of the hall to the right. So I write master bedroom, end of hall to the right, and then I go through the master bedroom. the master bedroom has a master bathroom, and it's at the front of the house. The reason I say that the master is at the front of the house is because it could be very noisy. So I always bring that to the attention of the buyer, even though they know it's there. You'll be so surprised of what buyers don't recognize when they walk through a house. So the number one bathroom is the master bathroom. And when you walk through the master bathroom, the first thing I see is corrosion around the sink because people have not wiped it down. The stopper in the sink does not work. It's just laying in the middle of the sink. Around the shower, there's corrosion and black stains on the floor. You don't know what the black stains are. It may not be mold. It may be mildew. It may be whatever it is, fungus, whatever. You just write that there's a black stain there so that they can investigate that any which way they see fit. So you're coming back out of the master bathroom, you're back into the master bedroom. And as you come out, you see above the doorway that there's smoke detectors. I always note the smoke detectors. So if you notice, I didn't note smoke detectors on the first two bedrooms, but I did notice one in the master. That's your first clue that before that appraiser comes, that you need to make sure that you have smoke detectors and carbon detectors in the property prior to your appraisal when you're representing the buyer. So you walk down the hallway again, and now you're in the hall bathroom. So you write bathroom number 2 off the hall, and it's pretty nice. So you write nothing noted. Another room could be an enclosed patio area. I'll just say there is one. The enclosed patio area may not be permitted, or it may be permitted. You don't know that. So you just state there that it may or may not be permitted, especially if you don't know. If you've seen the permits and you know it's permitted, you can say it is permitted. But most of the time when we do our AVID, we do not know that. In the covered patio, it looks like it's on the back of a house, so you know it's been added. And it is not put together correctly. So it's not installed as nice as it should be. Maybe it's one of those ones they got at the Ventura County Fair, something like that. You're going to note those things. Other room, you may or may not have other rooms. But if you do, you want to state what the room is, and you want to walk through it and say what you see. You notice there's 3 places for other. Other means anything else that you see that doesn't fit within the criteria of the form, you're going to want to write there. Things that I write there is that the property is back to a park. So there may be noise from children in the park. A block away is a railroad track. You don't know whether the railroad track is being used or not being used. You just have to state that there's a railroad track. They can investigate that themselves. But you'd be surprised how many buyers or even sellers don't even know that that's there. So you just state the obvious. If you hear a plane going overhead, you may want to say that it's in the flight zone of the airport so that they can check that out. So basically what you're doing is you're being the eyes, ears, and knowledge of what the property is looking like. If there's additional structures like an ADU, you're going to do a room or other structures. If you can put the information on this form, that's great. If not, then you need to do an addendum and go through that ADU and disclose what's in there. Garage and parking. If it has a garage, I state how big the garage is. It's a 2-car or 1-car. I don't measure it, obviously. If there's just a carport, I will say parking is just a carport. If there's any other common area that needs to be disclosed, like if it's a condo and there's common area where parking is on the street, or there's parking spaces, I will note that in parking. And now you're done with the inside of the house. And now you're going to look at the outside of the house. So again, I start at the front door and I go all the way around the perimeter. So at the front door, it may be that there's peeling paint at the front door. Maybe the door doesn't open as easily as you feel it should. You would note that. Maybe there's flowers and vegetation that's right up against the house that you can't see the walls of the house. You would note that. Any kind of debris that's anywhere around the building, front, side, or back, you'll want to note that. Whether there's a pool in the backyard, whether there's a hillside that goes down from the property that they have to clear, you would note that. In the last one that I did, it has a very large driveway. So it has RV parking and room for several cars. I don't say how many cars, because depending upon the size of the cars, depending upon how many cars will fit in that driveway. And then other observed or known conditions not specified above. That would be if you saw the neighbor next door that looks like maybe they're impeding on the property, which mine was. You would note that. The property that I did had a private road going from the street, the public street, up through a private road to get to the property. You would note that. And anything else that is applicable to the property. So on the property that I did, there is a road that goes from Highland up to Santa Cruz that allows large vehicles to impede on somebody else's property. That should be your first clue that there may be an association, and you need to check your title report to make sure that there is or is not an association there. In my case, there was one, and nobody really knew about it, and my seller didn't tell me until I asked him. So you need to be the professional and make sure that you're doing your due diligence on the property, because you will be held accountable for all of that as well. So now you're done with the property. It says this disclosure is based on a reasonably competent and diligent visual inspection of reasonable and normal accessible areas of the property on a specific date. The real estate broker is Century 21 Everest, and it is by you. You put your name there and the date that you did the inspection. And then both buyer and seller and both agents sign this form. It's like the transfer disclosure statement. Everybody involved in the transaction needs to see this, and everybody has to sign responsibility for it. So you notice that both the buyer's agent and the seller's agent are looking at the avid. If you're representing the seller, the buyer will have to do an avid as well. And then both avids will be given to both parties, the buyer and the seller. Very important piece of very important piece of disclosure to the transaction. All right, next form. Seller's license to remain in possession addendum. So this addendum is when the seller is renting back after the close of escrow for less than 30 days. If it's longer than 30 days, you do a different form than this one. Just make sure you know that. So everything needs to be explained that this is for 30 days or less. Usually there's an addendum to escrow and this form that states what the contract is going to be for the seller that stays back. Close of escrow shall be 0 days for purposes of counting days for the term of this license to remain in possession. So a lot of things can happen with this form. You're going to spell everything out based on the agreement that you have on your contract. You're going to write the terms of the rent back. The seller is granted a license to remain in possession for X number of days. It can't be longer than 29 days. So it can be 5 days, it can be 10 days, it can be 20 days. A lot of times it's just a couple weeks for the seller to remain in possession, but it specifically states the term, when they have to be out, by what time. And then it's your responsibility to make sure that that is adhered to. Consideration. In consideration for the seller agreeing to sell the buyer and buyer agreeing to allow the seller to remain in possession after close of escrow, the seller agrees to pay the buyer a non-refundable license fee for the term specified in number 1. Most of the time people don't charge a fee for that. I have never charged a fee for it in anything I've done. If you agree to let the seller stay, you're going to put a 0 right there, unless there's a specific reason why you are charging them to stay. Seller shall deposit funds in escrow prior to close of escrow, or such funds shall be withheld from the seller's proceeds. If you are charging a fee, you always want to do it through escrow. It's cleaner, and then the buyer and seller do not have to chase each other to get the money. Seller shall deposit funds with escrow holder prior to close of escrow, or such funds shall be withheld from seller's proceeds. At close of escrow, all consideration will be released to the buyer that was held in escrow. If seller vacates the property prior to the end of the term, no portion of the consideration will be returned to the seller unless otherwise agreed in writing. So you need to be very specific to the seller that if they leave without letting anybody know, they are not going to get reimbursed for the amount that they agreed to. Late fees and NSF checks, you won't have that problem if you have it held in escrow, but if somebody does give a check, you need to say what the term will be if the check is bad. And most of the time we don't do checks anymore, which is why we hold things in escrow. Maintenance. This is spelled out so that the seller who is staying back actually is responsible for keeping it in good condition, so that when the buyer takes back over, it's in the same condition as it was when they rented it to them. Delivery of possession. Seller shall deliver the property in the condition and the terms provided in the agreement. So things that have happened that I'm aware of, especially being a manager, I see everybody's transaction. And when you are renting back to a seller, it's always good to move things away from a wall. So if there's a refrigerator in the garage and you've not seen behind that refrigerator before you rent back to that seller, you need to make sure that everything is okay behind that refrigerator. We recently had a situation where the refrigerator coils leaked and there was complete stains and mold behind that refrigerator. So when the seller moved, the buyer was left with a huge bill to fix that. Well, then there's a disagreement of whose responsibility is that? Is it the seller's responsibility because it was there prior to close of escrow and they didn't know? Or is it the buyer's responsibility after the seller moves out? There's always a disagreement about stuff like that. So you just need to cover yourself to make sure that things are done properly. Delivery of possession fee, if one was required above, then the amount of the possession fee will be handled out of escrow. Utilities. The utilities need to remain on, and the seller who is staying needs to pay the following. The buyer can pay for them, but most of the time the seller pays for them. So seller agrees to pay for all utilities and services and the following charges. That could be maintenance of a pool, it could be landscaping, it can be anything that you need to put in there to keep the property in good condition. Entry. Seller makes the property available to buyer for the purpose of entering to make necessary and agreed repairs. I highlight that when I am doing this form so that everybody understands that the seller is going to live there, and if the buyer has repairs they need to do, that they are allowed to do that because it was agreed to in the contract prior to them staying. Supply necessary agreed services and show property to prospective and actual purchasers or tenants if they're going to rent it. All of that needs to be agreed to in a prior contract and reiterated in this one. Keys. Seller shall provide keys to the property as required at the end of the term of the seller license to remain in possession. I can't tell you how many times that the seller will give one key back to the buyer when they have everything to operate the property. Because you got to know that the buyer is waiting for the seller to move out and doesn't have any of the keys. And the seller is probably packing and ends up having one key at the end of the day. They need to give the mailbox key, anything there is to operate the property. Because guess what? At the end of the day, if they don't do that, somebody's going to pay for them. And it's probably going to be the seller and or the seller's agent. So it's always your responsibility to educate that seller to make sure that they give everything to operate the property, or they're responsible for the cost of that. Assignment and subletting. Seller shall not assign or sublet any part of the property. So subletting means that you're not allowed to rent it to anybody else, that the seller is the only people allowed to be in possession of the property. Is if the seller rents the property to a kid or a friend or whatever, then you have to have agreements for that. And it just gets too complicated, and the buyer doesn't have the right to, the seller would have the tenant in their name as the seller and not in the buyer's name, and that causes a problem. You also need to make sure that the proper insurance is in place when you are letting a seller stay. So the buyer has purchased the property, it is closed. The buyer is the owner. The seller is the tenant, technically, even though they've got agreement to stay past the close of escrow. The insurance of the buyer that just bought the property may not cover the seller because the seller is a tenant. So it could void the insurance policy that the buyer just got for his new property. They need to make sure that they have the proper insurance in place so that they are not covered if something happens. And that actually means from the minute that they take possession and the property is closed, that insurance policy needs to be in place so that anything that happens can be covered. The waiver of any breach shall not be constructed as continuing waiver of the same or subsequent breach. So everybody has to sign it, buyer and seller. And it really should be explained just like I explained it, to make sure that there's insurance and everything in place if the seller is staying in possession. Okay, seller's purchase of replacement property. The next form. This is an addendum to the purchase agreement or to the counter offer. Finding a replacement property. Well, you guys know in this market, it's very difficult to find a replacement property. So this form is going to be started to be used again in a real estate transaction. It's always market driven. The agreement is contingent on the seller entering into a contract to acquire replacement property. Seller has within 17 days or X amount of days after acceptance, remove the finding replacement property contingency or cancel the agreement. It's something that you have to keep track of if you have this as part of your contract. Or seller has entered into a contract to acquire replacement property, and then you give the escrow information and the escrow holder and the escrow number. And if checked, close the replacement property, the agreement is contingent on the seller's ability to close the escrow on the replacement property according to that contract. So if you accept the seller to find another property, you need to make sure that your time periods and everything are in place, and that this addendum is part of your plan to close the escrow. Time periods in the agreement for inspections, contingencies, covenants, close of escrow, and any other obligation that commence from the date of acceptance begin the day after the seller delivers to the buyer in written notice from finding the replacement property contingency. So their timeframes don't start until they found that property. Buyer's deposit. Buyer's deposit shall be delivered to escrow within 3 business days after seller delivers to buyer a written notice of removing the finding replacement property contingency as specified in 1A. Close of escrow. Buyer and seller agree that the seller may extend the close of escrow date for the sale of seller's property for a maximum of X days or until X date by providing the buyer with a written notice of the time seller removes finding replacement property contingency, if applicable. So if once the seller finds a property, you need all the information from that escrow so that you have that part of your plan so that you can make sure that the contingency gets removed at the close of escrow. Everybody has to sign that. Okay, transfer disclosure statement.
Well, let's hold. So we've done 3 contracts. Any questions on those 3 so
Oh,
far?
sure, let's go to questions, sorry.
Anything? Nothing in the chat? All right,
Okay,
doing a great job.
thank you. So the next form is the most important piece of paper in a real estate transaction. It is signed by the seller and given to the buyer. And the reason people feel that this is the most important piece of paper in the real estate transaction is that the seller said it was one way, and when the buyer moved in, they found it was another way. And that's your first flag of dispute. So your pen may not touch this piece of paper until the end, where you have to fill in for your avid. The seller must fill it out. I typically will help with the conversation about this piece of paper because a lot of people don't understand it. Your seller has to state that the disclosure of the condition of the property is in compliance with section 1102 of the Civil Code, dated the date that they signed this piece of paper, It is not a warranty of any kind by the seller or any agent representing the principal in the transaction, and it is not a substitute for any inspection or warranties that the principals may wish to obtain. Highly important, when anything is in caps in a transaction form, a disclosure, I read it to them. And the main reason I read it to them is because they don't always read our disclosures. And when something as important as this form, I read things that are in bold so that they understand that this is a liability, that they need to tell the truth. They need to disclose everything that they know, and that it could affect the value of the property based on what they say in this transfer disclosure statement. So with that, the transfer disclosure statement is made pursuant to 1102 of the Civil Code. Other statutes require disclosures depending on the details of a particular real estate transaction. So substitute disclosures, if there's substitute disclosures like a natural hazard disclosure report that may include airport annoyances, earthquake, fire, flood, special assessments, you can attach that to this transfer disclosure statement. This transfer disclosure statement also has a 3-day right of rescission. So if you do not deliver it within the time period, the time that you do deliver it, they still have that 3-day right of rescission. So you never want to wait till the last minute to give this to them because your buyer may have reason to back out. So inspection reports completed pursuant to the contract of receipt of deposit or additional inspection reports or disclosures will all be checked at the top there. Seller's information, the seller discloses the following information with knowledge that even though this is not a warranty, prospective buyers may rely on this information in deciding on what terms to purchase the subject property. Seller hereby authorizes agents representing the principal in this transaction to provide a copy of this statement to any person or entity in connection with any actual or anticipated sale of the property. I read that to them so that they get how important this form is. I also read the following are representations made by the seller and are not the representation of the agent. If any, this information is a disclosure and is not intended to be part of any contract between the buyer and seller. Then I explain how to fill out this form. So when you are sitting with a seller and going over all of your disclosures, you need to let them know that they can read this form from left to right. So they're going to read range, wall, window, air conditioning, pool, and then they're going to come back to oven, sprinklers, child resistant barrier, and so forth. So they need to state whether they have occupied the property or not. That will tell everybody how much they know, because if they are occupying the property, they know everything. If they're not occupying the property, they may not know much at all. So they have to check each one of the boxes that applies to their property. When they get down to exhaust fans, some of my clients have said, I don't know where the exhaust fan is. Well, most of the time an exhaust fan is in the kitchen, above the stove, or it's in a bathroom. A lot of people don't know what 220-volt wiring is. Most of the time it's in a laundry room or in a garage. Again, your pen may not touch this paper, but you can tell them where those types of things will be. And you need to be able to draw the plug of a 220 wire. So it's one that has 3 prongs. The plug is round and there's 3 prongs that plug into a special plug. And that will indicate whether there's 220 in the property or not. The fireplace, you need to state where the fireplaces are. They're either in a bedroom or in a living room, some in a dining room, or some are two-sided. You need to state that, or they need to state that. Whether it has a gas starter or not. The roof, a lot of people don't know what type of roof they have. Most of them are composition. And a lot of people don't know the age of their roof. They need to come up with an approximation. If they can't come up with this answer, I usually say, you know what, you may want to ask a roofer to come give you an estimate of how old the roof is, because it's real important for a buyer to know approximately the age of a roof. They give them the opportunity to give any other information about what they've already checked. And then it says, are there, to the best of the seller's knowledge, any of the above that are not in operating condition? If the answer is yes, then they have to explain what is not working. And they can do that on a separate form, or they can fit it into these two lines. Both the buyer and seller have to acknowledge the bottom of the page. And then we'll go to the next page. Number B, are you, seller, aware of any significant defects, malfunctions to any of the following? And they need to check yes or no. And by the way, if they don't check yes or no and they skip it, until this form is filled out correctly, the 3-day right of rescission does not start. So as an agent, depending upon who you are representing, if you're representing the buyer and some of these things are not checked, you want to send this transfer disclosure back to the listing agent with a note saying that this is not filled out correctly or properly, and get them to do that. Because you don't want to accept a transfer disclosure statement that's not filled out properly. They have to check each one of the boxes that applies. And if they've checked a box, they need to describe what's going on with the reason they checked the box. And they can add an additional sheet if they need to. So if they've had any kind of repair, or if something is still inadequate and not working, they need to state what that is. Then at the next is C. It says, you, seller, are aware of any of the following. I let them read this and go through it, but we're going to go through it together. So substances, materials, and products may be an environmental hazard, such as, but not limited to, asbestos, formaldehyde, radon gas, lead-based paint, mold, fuel, chemical storage tanks, contaminated soil, or water on subject property. If any of those things are present and they know it, they have to say. So if their house is built prior to 1978, it probably has lead-based paint. I have had every one of those things on properties in the past 31 years. So you just need to make sure that when you're talking to your seller, that if they know, they have to disclose. Features of the property shared in common with adjoining landowners, such as walls, fences, and driveways, who use or responsibility for maintenance may have an effect on subject property. Most of the time, that's yes. And the reason it's yes is because most fences are shared by property owners on 3 sides, most cases. So the answer to number 2 is most likely yes, unless it's in a rural area where there's no fences and no neighbors. Any encroachments, easements, or similar matters that affect your interest in subject property, like the one I just did, the answer is yes, because they have a private road and a separate road that they go over somebody else's property so that a moving truck, for example, can get through and come down and be on that private road. Room additions, structural modifications, or alterations or repair made without permits. So if there's a garage conversion, if there's an ADU on the property, any kind of those things, the answer to that would be yes. Any room additions, structural modifications, or alterations or repairs not in compliance with building codes. A lot of times they don't know one way or the other if something's permitted or not, especially if you're working with an elderly couple, they probably don't know. They still need to answer yes or no. They need to figure that out, and you can help them with that. Your pen again may not touch this paper. Fill, compacted or otherwise, on the property or any other portion thereof. A lot of people don't know that either. So if the lot was cut and the house was built, most likely is going to be on a soils report somewhere, and that could be recorded at the county. Most of those are recorded. So you'll need to ask the question. If they can't answer the question, you need to know how to get them to that answer. And that would be one way to do that. Any settling from any cause, slippage, sliding, or soil problems. If it's on a hillside, they need to answer that question. Or they can say it doesn't apply if it doesn't apply. Flooding, drainage, or grading problems. Same thing, if it doesn't apply, they can say it doesn't apply, they just say no. Major damage to the property or any of the structures from fire, earthquake, floods, or landslides. If it burnt down in a fire, then you need to say yes to that and then say that it was rebuilt or however which way. So we had the Thomas fire, the Woosley fire, and there was another one, I can't remember the name of it, but we've had several fires. So a lot of times this is yes in our area. And then you need to explain at the bottom where it says answers to any of these questions are yes, please explain. Any zoning violations, non-conforming uses, violations, or setback requirements. Most of the time, if somebody gets a violation on their property, they have received something from the county or the city stating that, and they will know. They don't always tell us that though. So you always need to check title and make sure that there's no notices of compliance or any kind of violations against the property once this is filled out for you. Neighborhood noise problems and other nuisances. So what is a neighborhood noise problem? In Ventura, you can hear the freeway on any given day from pretty much any property that's in Ventura, because we have 2 freeways that go through the entire length of the city, and you can hear that. In Camarillo, you also have the freeway, and you can hear that freeway depending upon how the wind is blowing. So you just want to make sure that they understand what type of nuisances or noise problems that there may be, because some people are very sensitive to noise. CC&Rs or deed restrictions or obligations, that would be for any condo. And guess what? There's CC&Rs for every property, and they are on your title report. So you'll want to check that. Homeowners Association, which has authority over subject property, that will always apply to a condominium complex. It applies to people that, like in River Park, in Village in the Park, in Seabridge, all of those areas all have associations. Any common area facilities such as pools, tennis courts, walkways, or other co-owned or undivided interest with others. A common area is anything that is taken care of by another party besides themselves. So a common area would always be yes with a condo, or it could be a gated area and the gate is taken care of by somebody else. That's how you determine that. Any notices of abatement or citations against the property, those will always be on your city report, and they always know about them. They may not remember, but they do always know about them. Any lawsuits by or against the seller threatening or affecting the real property, claims or damages by the seller threatening or affecting this real property, claims for breach of warranty or threatening to or affecting the real property. Anything that would cause the property not to close. So if they are behind on their payments and they are getting ready to have to short sale that property, that needs to be disclosed. If there's a bankruptcy on the property or on the people, that needs to be disclosed. If there's a lawsuit could be a divorce. You want to make sure that you disclose that as well, because you could have one party that does not agree, and that would cause the property not to close. And then if you've said yes to anything, you need to explain. So you would write, for example, number 2, that the fences are shared by other homeowners, as an example. Number D, if the seller certifies that the property as of the close of escrow will be in compliance of health and safety codes by having operational smoke detectors, which are approved, listed, installed in accordance with state fire marshals and applicable local standards. So you need to make sure that there is smoke detectors in the property and also carbon detectors. Everybody has to initial the bottom of the page, both buyer and seller. And then they need to sign at the top of page 3. And then the agents, both buyer's agent and seller's agent, need to check, see attached agent visual inspection disclosure, the AVID, that box needs to be checked. And then your company name needs to be there, which is Century 21 Everest, and your name is the licensee, and then the date that you did that. And then at the bottom, everybody needs to sign again. So you're acknowledging that you've received the AVIDs from both parties, the buyer and seller agent, and then everybody at the bottom needs to acknowledge all the forms. So as you can see, when everybody signs, everybody's responsible. They put everybody on the hook for it. And it's a very important piece of paper in our disclosures. If the seller is
Hey,
going.
wait, we have a question.
Yeah.
Andy, do you want to ask your question?
So if they're going through a divorce and they agree on all of the terms of the sale, they're signing all of the listing paperwork and all of the disclosures, do they still need to disclose that they're in the process of a divorce?
That would not, oh, good.
Wouldn't you say yes, Fred?
I don't think that's a pertinent information to the sale. So for the TDS, that's not subject to the property, no.
Okay.
Okay.
No.
Thank you.
So the seller property questionnaire, it's just another piece of paper that is prompting questions that are not on the transfer disclosure statement that they need to disclose to make the buyer aware of what's going on with the property. So this is just as important as the transfer disclosure statement. It's not a substitute for the real estate transfer disclosure statement by any means. It's additional information. So you're going to type in the address, the parcel number, the city of where it is, and the county of where it is. And then I read to them disclosure limitations. The following are representations made by the seller and are not the representation of the agent. This disclosure statement is not a warranty of any kind by the seller or agents and does not substitute for any inspections or warranty by the principal may wish to obtain. The disclosure is not intended to be part of the contract between the buyer and seller unless otherwise specified in writing. Broker and any real estate licensee or any person working with or through the broker has not verified the information provided by the seller. a real estate broker is qualified to advise the real estate transaction. If the seller and buyer desires legal advice, they should consult an attorney. So note to seller, this is any other material fact that is significant to the property that must be known. They do it to the buyer. They also have it here for the seller. And then seller awareness for each statement below, the answers to the questions, are you seller aware of, by checking yes or no, explain any yes answers in the space provided below. So let's just go over some of these, because a lot of times sellers who are filling these out don't always want to or think they need to answer these questions. So within the last 3 years, is there a death of an occupant on the property? It's either yes or no. And usually if it's a violent crime, you have to disclose that as well. In order from a government health official identifying the property as being contaminated by methamphetamine. I don't know about you, but most people laugh at that question and they say no. The release of a legal controlled substance on or beneath the property. Again, I use methamphetamine as a way to explain that to them. And I, knock on wood, haven't had that in any of my transactions in 31 years. So it's always been no. Whether the property is located or adjacent to industrial use zone, that would be a district allowing manufacturing, commercial, or airports. And that's an important part to determining value of the property, is whether it's located there or not. Whether the property is affected by a nuisance created by industrial use zone. So if there's, I was going to make something up. So if there's like for instance, if there was houses around the new Amazon building where there's traffic going back and forth 24 hours a day, you would want to say yes to that and disclose something like that. Whether the property is located within 1 mile of a formal federal, state, or ordinance location. In general, an area once used for military training purposes, like for instance, around our military base or around Point Magoo, which is another military base. In Camarillo, you can hear some of the training that goes on by Point Magoo. Doesn't happen very often, but it would potentially come to a buyer's attention if they moved from out of the area and heard some of those military training things going on. So if that's the case and you're within the flight zone, you would say yes. Whether the property is in a condominium or located in a planned unit development or any other common subdivision, any condo is going to be in that, Village of the Park, any of those developments that have been got Melrose or any of those other associations. Sometimes there's 2 and 3 associations within those. Insurance claims affecting the property in the last 5 years. So I've had people say no, and later I'd found out yes, because when the buyer goes and searches for their insurance, they have a method that they use, a system that they use where they can pull a clue report. And it will state whether the property has had an insurance claim in the last 5 years. So I always tell them they need to tell the truth on that one, because not always everybody wants to do that. Matters affecting the title of property. So that could be any cloud that you can think of on title. It could be if somebody's passed away and they haven't taken that person off of title of the property, that could be a matter affecting title. So they'd have to come up with a death certificate. Material facts and defects affecting the property not otherwise disclosed to the buyer. I always ask, is there anything else that you can absolutely think of that you haven't said already? And if that's the case, they're giving you one more chance to make that clear to someone. So plumbing fixtures on the property that are not compliant with plumbing fixtures as defined in Civil Code 1101. So if they don't have plumbing fixtures that are low flow, we also sign a disclosure stating plumbing fixtures are low flow. They have to disclose that. And some, like the one I just had, half of them were low flow and half of them were not. You still have to say yes and put half of them were and half of them were not. So both parties need to sign the bottom of that page. Repairs and alterations, if any modifications, again, that's kind of redundant because they've already said that on the transfer disclosure statement. They're giving them another chance. Same with any alterations for energy and water efficiency improvements or renewable energy. If they say yes to that, you're going to want to know what the improvement was and whether it is paid for or not. That is one of your red flags that will help you know if there's a HERO loan or any of the other energy efficient loans like a PACE loan. You'll just want to make sure that those energy efficient improvements have been paid for and they're not attached to their property tax. Ongoing or reoccurring maintenance on the property, drains or sewer cleanouts, tree or pest control services. If you see a huge tree in the front yard, you will want to disclose that on your Avid so that the buyer can discover whether or not that lateral line is compromised because of the tree. Any part of the property being painted within the last 12 months. My client was offended by that question because he did paint the outside and he wanted to know why they have to know that. Well, the reason they have to know that is if the seller is trying to cover something up by painting something. And that's why they have to know whether it's been painted or not. So you may get a little more questions about that when your seller is filling that out. I always seem to have someone that doesn't want to answer that question. Whether the property was built prior to 1978. Hopefully you have done your homework and you have your title report in front of you that will say when the property was built. If it was built prior to 1978, were there any renovations like sanding, cutting, demolition? It needs to be done by a professional and they need to disclose what they've done with that. Were any renovations done in compliance with the Environmental Protection Agency, lead-based paint renovation rule? Yes or no? If they've had work done to the property and they didn't do it properly, they need to disclose that. Structural systems and appliances, defects of any of the following, past defects that have been repaired. If they've had any of those issues repaired, they need to disclose that. It's just trying to get them to let the buyer know of anything that has happened to the property in the past and what they've done to repair it. Leasing of any of the following on serving the property: solar system, water softener, water purifier, anything that they are paying for that is not theirs. So if they're leasing anything, they need to disclose that. And then you need to know how much that is so that you can disclose that to the buyer as well if you're representing the seller. An alternative septic system on or serving the property. So sometimes a septic system is shared and sometimes there's more than one on the property. So they just need to disclose that and explain where they are. And most of the time in your contract, if you have a septic system, you know that ahead of time because they have to put that in the multiple listing service. And you will want that certified and pumped and made sure that it's in good working order for your buyer, and the seller is responsible for that in most cases. Disaster relief, insurance, or civil settlement. financial relief or assistance, insurance, or settlement sought or received from any federal, state, or private agency. So if they've received money for the fire or an insurance claim or anything else, they need to disclose that and what the repairs were. Water-related and mold issues, water intrusion, any leaks from any appliance, pipe, slab, roof, standing water, drainage, or flooding, they need to disclose that as well. A lot of people don't understand that if they have a drip in any kind of pipe or out, inside or out, they have to disclose that. Any problem with infestation of mold, mildew, fungus, spores, past or present on the property. If they've had any of those issues, they usually have a receipt for it to fix it, or they can say what they've done to do that. If there are any rivers, streams, flood channels, underground springs, high water table, flood tides, or anything affecting the property or neighborhood, you have to disclose that. So if you are selling a property at the beach and on occasion the tide comes in, you have to disclose that. You also have to disclose if they're within the range of a tsunami, which we have posted signs at our beach, and in most cases where the tsunami warnings are. So you need to make sure they disclose things like that as well. In Oxnard, there's a water table. It's a plane. Most of the time you need to disclose that it is a plane and it's on your NHD report as far as the water table goes. Pets and animals. The reason they're asking for pets on or in the property is so if someone is allergic or has a high sensitivity to animals, that they know what kind of animals were in the property. Problems with livestock, wildlife, insects, pests on the property. The property I just sold backs to a canyon. There's snakes, there are coyotes, there's skunks, there's all kinds of wildlife animals because it backs to a canyon. You need to disclose that. Any past or present odors with urine, feces, discoloration, stains, spots, or damage to the property. They also need to disclose that. I can't tell you how many times people come and take carpet out of a property and find out that there's been huge stains on the carpet and it's contaminated the concrete underneath it. They come right back to the seller. If they've done anything, they need to say who they've done it by and explain that. Boundaries and access to property used by others. If there's any easements or encroachments on the property, you need to say. And that would be that private road or the road that accesses large vehicles like moving vans or trash trucks. In the case of my listing that we're referring to all the time. Use or access to the property or any part of it by anyone other than you with or without permission for any purpose, including but not limited to maintaining roads, driveways, or other forms of ingress or egress or travel or drainage. Really important. So if you have to go across somebody's property on your driveway to get to your house every single day, you better have that in writing. I just had a property recently that had an easement between the two pieces of property, between two fences. The property above it had to pay $10,000 in order to remove that little 5 feet by 30 feet piece of property that wasn't included in either of their title reports. And so when the buyer bought that property, he also had to buy that little piece of easement from the owner below them. So that was a big deal. And that was not disclosed on this form. And we found out before close of escrow that it was untitled, that it was a separate easement owned by an entirely separate person. That should have been disclosed on this form. Next page. Landscaping, pool, and spa. Any diseases or infestation affecting trees, plants, or vegetation near the property. So if you have a dead tree or dead vegetation, if the grass is dead, any of that stuff you have to disclose. Operational sprinklers on the property, pool heater on the property, spa heater on the property, past or present defects, leaks, cracks, or repairs, all have to be disclosed. Condominium, common interest developments, and other subdivisions. Any pending or proposed dues, increases, special assessments, rules, changes, insurance, any of the things that are in an association package. If there's anything that the homeowner knows, they must bring it to your attention prior to getting that HOA package. Any declaration of restrictions of architectural committees that have the authority over improvements made on the property. Like an association, you have to get things approved by a committee in order to paint anything or add anything to the outside of the property. All of that has to be disclosed. Any improvements made on or to the property without required approval from the architectural committee, in consistence with any declarations or restrictions or architectural committee requirement. In the CC&Rs, most of the time it will give you who that architectural committee is and what the rules are of what they have to do in order to submit what they want to do to get approved. Title, ownership, liens, and legal claims. Any person or entity on title other than the seller signing this form. If you've done your homework, you will know that already by the time you get to this point. If there's more than one seller that's required to sign on your contracts, they will be on title. Leases, options, and claims affecting or relating to title or use of the property. So if there's a tenant, then you need to disclose that. Past, present, pending, or threatened lawsuits, settlements, mediation, arbitration, tax liens, mechanics liens, notice of default, bankruptcy, or court filings or government hearings affecting the property. Every time my seller or sellers have seen this question, they always have a lot of questions. You need to be able to answer those questions. Most of the time, if there is a divorce or any kind of a settlement or a tax lien, you have to know about that so that you can make sure that you can get that cleared prior to close of escrow. If there's a divorce decree that needs to be brought to someone's attention or a death certificate, there's a lot of questions about that particular disclosure. Any private transfer fees triggered by the sale of the property in favor of private properties, charitable organizations, or interest-based groups and other person or entities. So there's a couple of condominium complexes, 3 that I can think of, that have in their title report that at the time of transfer, the seller will make a charitable donation to the builder's charity of choice. I am in escrow right now on Lennar condos in Ventura, and there is that charitable organization. They have to make a donation of $2,100 every time that sells to that organization because the builder put that in place. Did my seller know that? No. Did the buyer know that? No. We didn't know that until I pulled the title report and read the title report, and it clearly states that there is a transfer fee that goes to a charitable organization right in the title report. So you just need to make sure that they are aware of that, and if they're not, that you make sure you disclose to all parties in the transaction through escrow that charitable part of the title is in there. I was surprised by that myself. Any paste liens, such as a hero or a CSEP, or any other lien to the property securing a loan to pay off any alteration, modification, or replacement or improvement, or any remodel or repair. This is where if you walk up to a property and you see the artificial grass in the yard, or you see new windows, or you see solar panels, or any kind of improvement that you know a hero loan or a PACE loan would possibly be there, you need to ask the question if it's attached to their property by property taxes. Because PACE loans and hero loans, most of the time there's not a payment due for 3 years, and they let them buy the necessary materials, install them, and a lot of times they forget because they're not making a payment for 3 years that it's even there. I've had that happen as well. The cost of any alteration, modification, replacement, improvement, or remodel or material repair of property being paid by an assessment on the property tax. Same situation. A lot of times I will ask them, if they don't know the answer to that question, I will ask to see their property tax bill so that we can see what all of the things are that they pay on that property tax bill. And then that will make it clear. Neighborhoods, neighborhood noise, nuisance, or problems, sources such as, but not limited to, neighbors, traffic, parking, congestions, airplanes, trains, any of the things that you see as a problem, you need to help your seller understand that those are things that need to be disclosed, including cell phone towers. So a lot of people are very sensitive to cell phone towers and the admissions that they give off. You need to make sure that that is disclosed by them. Next page. Governmental. Any zoning or annexation needs to be disclosed. Eminent domain. In Ventura, we did have a few things that got taken over by eminent domain, and that question would have been answered yes, and then that explanation would have happened. If they get a notice saying that the county or the city is considering eminent domain, that is a big reason for them to say yes to that and disclose that. It may not have happened yet, but the fact that it's on the 5 or 10 year plan, that needs to be disclosed. I've had that as well. Existence or pendency of any rent control, occupancy restrictions or improvements, retrofit requirements that could apply or could affect the property, any current bonds or assessments that do not appear on the property tax. So at River Park, you have bonds and assessments and HOAs. All of that would be yes. Proposed constructions, configurations of government facilities and amenities, such as schools and parks. That's pretty much a no-brainer. Existing or proposed government requirements affecting the property, such that tall grass, brush, or other vegetation needs to be cleared. That would be if you had to clear around a property, which I had on my property that I've been referring to. Any protected habitat for plants, trees, animals, insects that could apply or could affect the property. When a new development is done, and I've had this too, we found a red-legged frog at the property, at the site where the property was being built, and it halted all construction until they figured out where that red-legged frog came from, which was the river bottom, and it delayed building of properties for about 3 months. So you don't want to find anything like that. Whether the property is in a historical designated area, which falls within an existing or proposed historic district. I recently had that situation in Piru, where the seller did not disclose that it was in a historical district. And we have probably a pending lawsuit because of that. The seller did not disclose it, and it's nowhere other than on a notice of non-compliance was that found. Any water surcharges or penalties imposed by public or private water supplier, agency, utility, or restrictions, they're going to know that and disclose that. Any reports or inspections, disclosures, warranties, maintenance recommendations, estimates for the property for easements or encroachments, they should know that. A lot of people don't know that, so you may have to help with that question. Any occupant of the property smoking any substance on the property. I get people all the time that say that's none of anybody's business, what I do on my property. Well, the reason that question is asked is because a lot of people are very sensitive to smoke of any kind. And you don't want to be sued if you didn't disclose that. So because it's a question, they have to answer it. Any past or present material facts other than significant items affecting the value or desirability of the property. What's the question? Did she say frog or fog that halted the transaction? It was a frog, a jumping frog. Red-legged frogs are on the extinct list, and a kid found one. Number 18, check any additional comments. So attached addendums contains an explanation of additional comments and respond to specific questions answered yes. So they have to explain anything that they say yes to. And then the buyer and seller have to acknowledge that. So that's a lot of stuff. Is there any questions about those disclosures? Because those are the most important disclosures in a real estate transaction. No questions?
I actually have a question.
Sure, Lillian, go ahead.
Okay, so not about the frog, but you mentioned in Avid that there was a bookcase that you weren't sure if it was built in or not, and you felt it was important to disclose or permitted or not. I can't remember. But anyway, are we really responsible for mentioning even something like this? Because it might, I'm afraid that if we mention about one bookcase, it might give the buyer the false impression that we know about everything else, but with this bookcase, we're not sure.
Well, in this particular situation, you could see that it was raised just a little tiny bit off the ground, like about 1/8 of an inch or 1/4 of an inch. And so it's unclear whether it was attached or not. And my seller was nowhere to be found when I did the Avid. So I felt necessary to say about that disclosure. If it's attached and sitting on the ground level, then you probably don't have to disclose that. But if there's any indication that that bookcase may not be attached and they think that that is staying and it's not, then you need to disclose that.
Okay, I can understand that. Now, a follow-up question to that is that we live in an earthquake country, and a lot of furniture are, for example, in my house, are attached to the walls with the earthquake strapping kit. So technically they're attached, but they're not really staying if I were to sell my house. So
Yes.
how do you, for the purpose of attached or not, how do you consider those?
Well, the seller needs to tell you what this, you would have to tell the buyer whether it's attached with a kit and you're taking it and then you're going to fill the holes from the kit or not. That's not something you're going to be able to see when you do your visual inspection. That's
Okay,
something that you would have to disclose because you know it.
right. So I guess if it looks like personal furniture, like part of a bedroom set, for example, and I have this huge armoire, that is in the back, concealed, it has a concealed attachment in the back. Even though it, unless you'd have to do like an invasive inspection or pull the furniture away from the wall, then you would see it. Even though you can't possibly assume that something like this is built in, you would still have to disclose that it is attached and it has to come out.
Yep,
It will come out. Okay.
absolutely.
Okay, cool.
Because
Thank you.
otherwise the buyer's going to assume that you're going to leave it. And when he comes and does his final walkthrough and you've already packed it and it's gone, he's going to want to know where it is.
Well, but my point was that the buyer couldn't possibly assume that I'm going to leave it because, like I said, the attachment cannot be seen. It's concealed behind the furniture.
Right,
You would have to pull the furniture away from the wall to tell that it is in any way attached.
right. So that's just something the seller is going to have to disclose. That I have.
So that means anytime I walk into a house and I can't see that the seller has earthquake straps behind the furniture, do I really need to have that conversation about everything, every piece of furniture that could possibly be attached with an earthquake strapping kit? Is it attached or is it not? Because I've never had those conversations because like I said, you can't see those attachments unless you climb on something.
Yeah,
and
you're
unless
not going to move any furniture.
Right.
But if you
Right.
suspect that, Liliana, if you suspect that, you're going to ask the seller, do you have all of your furniture attached by an earthquake strap? If you suspect
Okay.
that, because you have it in your house,
I live in an earthquake country, so I should always suspect that because I would think that
Right.
anyone in their right mind would do that. Especially, if they have pets or kids that don't necessarily know to run away from falling furniture. But
Right.
I guess it always has to be assumed because of where we live, right? And
Absolutely.
what I mean is, are we taking this a little too far?
No, it depends. It depends on what you see. If you suspect that when you go in, like I suspected that it may not be attached,
Okay.
right? If you suspect that, you're going to ask more questions to that seller for your
Okay.
app. Like I always have a list of questions for my seller when I'm doing an Avid of things that I want to know. Which way is it? Is it staying going? Do you hear airplanes? If I hear an airplane while they're gone and I'm doing the Avid and the inspection, when they get back, I'm going to say, do you hear airplanes like 3 or 4 times a day? Or is that just one time a day? Or is that just a coincidental that I happen to be there when that airplane went over?
Mhm.
So I'm going to ask more questions about that. So if
And
you,
if it is just an accidental, do you still disclose it or not?
I'm sorry, what? If what?
And if that airplane was just an accidental one-time thing, do you still disclose it or not?
No, I don't.
Okay. All right, thank you.
You're welcome. All right, next disclosure. This is a new disclosure. It came out December of last year. It's called the Home Fire Hardening Disclosure and Advisory. And so if your property or their property is built or constructed before January 1st, 2010, and it is located near a high or very high fire hazard area, then this form needs to be filled out. How do you know that? Well, you know the date that the property was built, so you know that. And if you have your NHD report, it will state on the report whether it's in a high or very high fire hazard area. So the seller does need to complete it if you suspect it. So if you suspect that it's in a high fire hazard area, which in Ventura, to be honest, at the Thomas fire, we had no idea that that fire would come over the hills as fast as it did and burn the entire hillside down in Ventura. Never in my wildest dreams, I've lived here all my life, never seen anything like that happen before. Is it in a high fire hazard area? Well, on the NHD report, it says that it's in a high fire hazard area on most NHD reports in all of our hillside now. So if you don't have access to the NHD report, you can look around, and if it looks like it's in a high or very high hazard area, you're going to want to fill this form out. Charlene Simone, which is our broker, her opinion is that if it is built before January 1st, 2010, that the form must be filled out anyway. So,
Question,
yeah,
why would it be only for properties built before January 1, 2010? Is there any particular reason, like are properties built better after 2010 or something like that, in case a seller asks?
because after January 2010, there's new fire codes for building. And that's why that date is there.
Okay, thank you.
No worries. So if you don't have access to the natural hazard disclosure report, you probably want to have that in your possession. There is a website, readyforwildfire.org, that you can send your clients to help them fill this form out. In the property that I've been referring to, my client didn't have a reason to check any of those boxes at all. It didn't apply to him. And home fire hardening final inspection report, if checked, seller has obtained a final inspection report that includes compliance with certain defensible space and home hardening requirements. I've not seen one of those reports, so I don't know. Fred, have you seen one of those reports?
I have not, and it's not a report that you go out and have someone come for an inspection. It's a report that when your property was built, you would have that report.
Oh, got it. Okay. Good to know. So then you just have the seller sign at the bottom of that. So primarily it's if you suspect that it is and your NHD says it is, then this form needs to be filled out if the property was constructed before January 1st, 2010. Okay, and lead-based paint. Lead-based paint is for properties built prior to 1978. And basically it's to notify the buyer that such property may be present to exposure of lead from lead-based paint that may place children at risk for developing lead poisoning. That's the main purpose for the warning, is so that kids do not get lead-based paint. If lead in kids do not go away once they've been exposed to that. Lead warning statements, lease or rentals, you have to provide this to a rental as well if the property is built prior to 1978. And if you've done any lead-based paint renovation, repair, or painting, you have to have contractors that are professionals that work in pre-1978 housing. If it's close to a child care facility or schools with lead-based paint, their employees must be trained and follow protective work practices in order to remove that lead-based paint. The seller needs to disclose that. There is an environmental hazard earthquake safety disclosure that we have to provide, and we provide a link to that. So the seller has to sign, and the buyer and or tenant has to sign at the bottom. The listing agent has to sign that they're aware that the property is built prior to 1978 and the information about lead-based paint. The buyer and the tenant will have the disclosure from the Homeowner's Guide to Environmental Hazard and Earthquake Safety. It's a pamphlet and a link that they can go to, and then they have to sign it, and then the cooperating broker also has to sign it. So any questions on that?
Nope.
Okay. Let's see, we have a couple more. Real important form, notice for seller to perform. It's the NSP. You can use number 1, 2, 3, 4, as many as you need with this form, because there's lots of boxes on it that will require the buyer and or seller to do whatever they're missing. So it says buyer hereby gives sellers notice that the buyer has not received from seller the items checked below. If the seller does not provide buyer with these items, the buyer may be entitled to cancel the contract or delay removing the contingencies. So contractually, delivery of the inspection report, delivery of fully completed lead disclosures, fully completed statutory disclosures, any booklets and guides, condominium HOA disclosures, disclosures of known property insurance claims, like a clue report, delivery of the preliminary title report, the capacity signature disclosure, or any other contingencies or any other disclosures regarding a contingency. Says seller, if you do not take contractual action specified above within 2 days after delivery, this notice for the seller to perform, the buyer may cancel the agreement. So it's an action form. If somebody is not performing to the contract, you can use this form to entice them to perform, or they can cancel. Demand to close escrow. If everybody is doing everything that has been agreed upon in the contract, except for closing, then you can send a demand to close. So you've done everything you can to request the buyer to close escrow. And for whatever reason, they're delaying, whether it's a lender not returning a phone call and letting you know what's going on, or a buyer not doing what they need to do, you can demand to close the escrow. And this is a form that you use to do that. And if they don't close the escrow within 3 days, then they can cancel the contract. And then the last page. Yes, Fred?
That's it. Oh, the report has it. I don't have it on my list, but okay.
Oh, yeah. She sent me the hazard booklet receipt.
Okay, perfect.
It has all of the links to all of the safety requirements and the lead-based paint, environmental hazards. And you just need your clients to sign the bottom that they've received the link so that they can go to that particular booklet. So that pretty much concludes our class. Does anybody have any other questions?
Lots of information.
Lots of information, lots of things you have to know. And these are probably the most important disclosures from the seller. So.
I have a question.
Sure.
So I think in this class, we were discussing the SIP form, seller in possession, right? I want to make sure my question is not out of place.
Sure.
Yeah, so in the MLS on my listing, I had stated that seller will, that possession is to be COE +2. However, when I received the offer, well, multiple offers, that when we ended up with an offer that we accepted, I realized that the SIP was never included. So what's my recourse now? And is it too late to submit that to the seller, or what do I do about it?
Okay, well, I think we lost you at the end, Liliana.
Oh, I'm sorry. I was saying that the form, the SIP form, even though my listing on the MLS states that seller will need a couple days to move out, the COE +2, the offer didn't include the SIP form, and we still had not addressed it. We are about, I don't know, 4 or 5 days after acceptance. So what do I need to do now? Do I just type up an SIP form and send it to the buyer side, or what do I need to do?
Okay, did you get that, Karen? Or,
I got like, it's so broken up that I couldn't really
Okay.
understand the whole question.
so the question, it's okay, Liliana, your mic's not working.
No, it's my internet.
Okay, the question is, she has in the MLS that it's closed escrow +2.
Yeah,
She had multiple offers. She accepted an offer. The accepted offer did not have an SIP at that point, and they're about 4 or 5 days in escrow now. What is her recourse?
well, you're gonna have to come to an agreement on that. It wasn't in your offer that they were going to stay 2 days past the close of escrow?
Right.
Correct. It wasn't in the, it was in the MLS only, but it wasn't in the counter offer or the purchase agreement.
So you can do it a couple different ways. You can do an SIP, or you can do an amendment to escrow stating that the buyer is going to allow that to happen.
Right. So the question is, but if I do the amendment into escrow, I still need the SIP form, right?
Correct. You need
Correct,
the
yes.
SIP form and the buyer needs to agree. They don't have to agree at this point.
Right,
Okay, got it.
Yep.
All right. Thank you.
terrific.
All right. Great
Okay.
class. We have one more day to go and we will see you tomorrow, same time, 9 o'clock.
Great. Thank you so much, Fred. Appreciate
Thank
you.
you, Karen. Great job.
Have a good day, everybody.